Hello and welcome to Counterpoint. I'm your guest host, Michelle Simard, and today we'll be talking about the new proposed privacy legislation, Bill C-27, and why it's important we discuss what it entails, what it doesn't, and how best to protect yourself moving forward. Today we have Vanessa Henri, lawyer and co-founder of Henri & Wolf, a cybersecurity and data governance lawyer, to discuss this upcoming legislation and what we should know about. Hello, Vanessa.
Hi, Michelle. Thank you for having us.
Oh, you're welcome. So as you know, on June 16th, 2022 this year, which is about a month ago, the Canadian government tabled Bill C-27, an act to enact the Consumer Privacy Protection Act, the Personal Information and Data Protection Tribunal Act, and the Artificial Intelligence Data Act to make consequential and related amendments to other acts. Now, that's a mouthful, and there's no shortcut to say it, but this bill is designed to update Canada's federal private sector privacy law, the Personal Information Protection Electronics Document Act, which, as we all know, is PIPEDA, and to create a new tribunal and to propose new rules for artificial intelligence systems. And as you know, Bill C-27 is a reworking of Bill C-11, the Digital Charter Implementation Act, which died on paper with the announcement of the federal election in 2021. So I'd like you to tell us your thoughts on the new legislation so our viewers can see what they need to expect.
Of course, of course. Well, as you mentioned, it's a little bit of a piecework of legislation. And for those who are not lawyers, it's a little bit daunting to read because it is amending other legislation that
Agreed.
You probably don't know. So at a high level, to take a step back, PIPEDA, which was the original law, was based on privacy principles that were attached as annex to the law. And over the time, there has been a number of guidance that were issued by the Privacy Commissioner. So some of the modifications are not entirely new. There are actually codifications of things that have been in the guidance. Unfortunately, the Privacy Commissioner having no power to enforce that guidance without going through significant hurdles, they have never really translated into law. And I think most businesses have understood this as recommendation more than what they should be doing. Now, the new law makes it clear you should have a privacy management program. It makes it clear when and how you should have a consent. So what it does is it clarifies a number of things, and it also moves a little bit towards GDPR, which is an European data protection law, in that it makes a distinction between the service provider and the organization who is in control. But it also has its own Canadian feel to it, where, for example, there's a distinction between anonymized and de-identified data, which I think is a great distinction that we are introducing here. So it is modernizing, but as I'm sure we'll have the chance to talk, there are topics which are not covered, which I think at least experts in the field would have expected to have a discussion over this, especially given in the last 2 years that these discussions were prominent.
Yeah, I agree. And one of the things, I mean, obviously it's great that it's updating PIPEDA because, as you know, for our viewers, PIPEDA is a legislation that's been over 20 years old. And it clearly needs some updating because things have changed. And the fact that it's now adding something, which I would argue, like you said, that is good for Canada and it's unique, is that we're adding artificial intelligence, which in the previous act, Bill C-11, that wasn't included. So I think this is definitely a step up. But the question is, I mean, there's always something that can be done more. I think so. But the question is, what do we need to take away? What's important and what is missing? And so we're going to delve a little bit more into that. But I just wanted to know, when you first heard about it, what was your initial thought? Because there's always a gut reaction. And usually the gut is usually something that leads us.
For sure. So for a little bit of background, PIPEDA has always been very difficult to modify. So there has been several attempts in the past. So C-11 wasn't the first one to make modification into PIPEDA, and different group of interests, whether it's journalists or other group of interests, have opposed it. So why I'm explaining this is my first reaction was, wow, that's ambitious, right?
Yeah.
Not only do we want to modify the law, we want to create an entire tribunal that's going to be dedicated to the appeal of something that some rights we didn't even have before. We're modifying a number of other legislation as well, and we're introducing artificial intelligence. And the risk of having all of this into one bill is that it is then refused entirely because maybe we want to cover artificial intelligence and not just privacy. So my first reaction was, why wouldn't they break it down into pieces to make sure a little bit is going to go through, if not the whole thing?
Perfectly said, Vanessa. I totally agree. I think that the best term to describe this is ambitious. And we're going to talk about this ambitious after our break. Welcome back. We're here with Vanessa Henri, and we're talking about the new privacy legislation, which is a very long name, so we're just going to keep calling it Bill C-27. So as you discussed, Vanessa, we find this legislation a little bit ambitious for various reasons, but mostly because it incorporates several acts within one act, and at the end, it may not be passed by Senate. So, I mean, it may be a roadblock, but it may not be. It could be a good thing. But I think we should talk about what the most important thing that is really missing from all these legislations, and that's the fact that privacy was not made a right. What are your thoughts about that?
Correct. So you have in Article 5 of the laws, it says that the objective is to recognize the right to privacy individual out of our personal information. But that right has not necessarily been thoroughly recognized in the law. Really goes quickly over this and what is really a right to privacy over personal information. Then the law goes on talking about consent, which makes people think, well, so my privacy is a consent. It's a business practice. So what is my right to privacy over personal information? I think that's a big elephant in the room, and that has not been clear. We have a right against unreasonable search, but definitely not a positive right to privacy into the Constitution like those in Quebec have. We don't have that at the federal level, even if mentioned in the law.
Yes, correct. And I think that's one of the failings of it. And I'm not quite sure why. I mean, I guess we'll have to go through maybe some Hansard notes there to figure it out. But in the meantime, yes, I think that the one biggest thing it's missing is not making privacy a right. And perhaps it will later, because I think that as things progress, especially with artificial intelligence, and we're going to see how companies get more and more into acquiring more information and using artificial intelligence, that I do think that privacy will have to meet a right. And if not for adults, at least for children, because I don't think that children completely understand when they go online and what they do, and they may not even understand the difference between an artificial image and one that is not. So at that point, there'll need to be some rights because there's definitely going to be abuses. So that being said, we've talked about what the biggest thing it's missing, but let's talk about some of the good things it has, because there's a lot of great things that this new bundle, I'm going to call it, legislation has, because we're going to have a tribunal now, and that's very different than what we had before. So let's talk about that.
Correct. So there's a number of things that is introduced into that law that is either a Canadian invention, and that's great. For example, we have international transfer that are not covered, but then we have introduced at least a notion of when we transfer the information to a service provider. So that wasn't very clear before. It was kind of all in the guidance and not into the law. We've introduced also this new concept of de-identified data versus anonymized data. So to sum it down and make it very simple, de-identified data, it's a little bit like you anonymize, but not with the same quality of anonymization. So there's a risk that it's going to be re-identified. So that distinction is a Canadian distinction that has already passed in Quebec. So we're well on the way to cover this. And not only that, we also introduced the notion of automated decision-making system. And in Canada, it's not just that it's doing its thing on its own. It can also be assisting somebody to make a decision. And that is a step in a different direction than what we have in the EU, because in the end, it was really easy to go around that provision by saying a human's operating it, so it's okay. That will not be possible with C-27, and that is a step in the right direction from what we currently have in the law in terms of using your personal data in an automated manner.
I agree. I think what's really important is the fact that the distinction was there, and we weren't really leaders in Canada. Like you said, you brought up the GDPR, which is in Europe, and of course there's a CPPA within California and the United States, and of course the United States has the new legislation coming up. But what really made us unique was, I think, that we separated these things between anonymized and segregated, desegregated. I think all these definitions for the everyday people may not be important, but I can assure you that they are important, because some information, even though it may be segregated or de-anonymized, it could still be found, backed, and traced you. And now we're having these types of rules and regulations that are governing the way businesses are doing and collecting information. The most important being is the mitigation of data, meaning that businesses can only allow a nominal amount of information that they collect only that can be used for the purposes of their business, whereas before it was a free-for-all. It was the Wild West, and but businesses could take as much as they needed and wanted in order to sell the services that they had. So that being said, we're about to go for a break, but Vanessa, do you agree or disagree on that point?
I agree. I think it's great that we have the notion of consent. Yes, it's still there, but businesses have to show that there's still a legitimate purpose. So your
Yes.
factored consent that maybe is not informed will not be sufficient to pass the test. So there's a
Okay.
double standard.
Okay.
Very interesting.
Yes, thank you, and we'll be right back. Hello, everyone, and welcome back. We're here with Vanessa Henri, and we're talking about Bill C-27, the new privacy legislation that is brought about by the federal government. So, Vanessa, as you know, we were talking earlier about some of the new things that were added and what's good about it, and obviously what's missing, meaning privacy not being a right. But let's talk about the next piece of legislation, because we talked about the privacy, but let's talk about the one that's talking about the tribunal and what that means and how is that beneficial for people.
So one thing the tribunal does really is to create that expert or that specialist division that will tackle data matters and also artificial intelligence matters. So one reason why this is there that I can assume, I think there has been some type of loss of trust into the justice system being able to tackle these hard and difficult technology questions. So obviously having this body of lawyers and judges that are specialists will lead to better legal precedent that will be more updated and hopefully will go through the tribunal fast enough to be a trustful referral we can look at and see, well, this is reasonable or this is not reasonable because there's a legal precedent. Today, we have very little legal precedent in the field. So that would be if it's carried to term, because once again, it's ambitious. But if it is carried to term, it will create a legal profession that is specialized into that area.
Yeah, I agree. And what I think would be really important is because, as you know, this area is kind of similar to, intellectual property. And, most intellectual property matters are dealt with in the federal court, and you have people who have expertise in it. What I would expect from the tribunal is people who have expertise. And it's not just placing people in it or just training people in it, because I think with the breadth and depth of information that's out there, I think it's really key for people to really understand and hone those skills of what it is and to comprehend it, because it's difficult. Everything is constantly moving, and we're not quite sure what direction it's going to go. And hopefully with this legislation, we can kind of guide it somewhere towards there. I thought also what was interesting is they were going to equate the tribunal's powers to those equal to the Superior Court, which is, really good to kind of have that kind of equality within kind of jurisdictions, within different types of judgment courts. But I think there's still an issue of even if someone is successful, I mean, what does that do for them? Will they get the award? Do they have to chase after it? I think we're still going to deal with some of those hurdles, and perhaps this is just a wait and see approach. What are your thoughts about that?
Well, there is in the law a new right to private action. So what that means is that you and me can just go and actually enforce our own right. But that right is still conditioned on either the tribunal or either the commissioner making a conclusion. So you cannot just be, oh, well, I was a victim of a security breach and I want to do a complaint. That is still not accessible to you. You still have to go through the commissioner, and if the past serves as an example, it can take easily 2 years before you get that conclusion. And then you don't have 3 years to go to court. You also have a delay that is shorter to take action and go through the tribunal. So does that entirely solve the issue of giving a voice to individuals over their personal data? It will depend on how efficient the privacy commissioner is at carrying to terms all the complaints it will receive.
Agreed.
And then again, then again, the tribunal as well, right? Will it take 2-3 years before we get the legal precedent? That's to be determined.
But also there is a plus to it, as opposed to the privacy tort of inclusion upon seclusion, where you would have to hire a lawyer and it would come out of your pocket to do it. With a tribunal now, it won't come out of your pocket. So if those who do have their privacy rights breached in some way, whatever privacy rights they may have, because they don't have a right to privacy, but they have some privacy rights, they can at least go through it and it won't be coming out of pocket. So there's some form of access to justice there. So I do think in that respect, it's definitely a plus for that part of the legislation. And I think that's really important for those who feel that sometimes their privacy rights are negated, or they may be scared of saying something or doing something for fear. But I agree, the length of time and how it's going to be dealt with is definitely going to be a problem. And there's definitely going to have to be some guidance on that in some part, just like other issues with the legislation.
Correct. And the thing we have to read through there is that a private right to action doesn't exclude people coming together to exercise. So what it does is it really opens the door to class action lawsuits. So from a business perspective, it's scary. It's a deterrent, and it's something you should take seriously.
Yes, I agree. And as you know, the recent Court of Appeal decision on Ontario was reaffirming from the Jones versus Singe case, discussing how the class action it didn't meet the threshold, but it didn't meet the threshold for a class action. It wasn't necessarily for the breach of the privacy rights. So that's kind of interesting too. So we're going to have to see how this tribunal kind of deals with the milieu of different kind of cases from the privacy commissioner, from the actual superior courts, and now going to create its own type of jurisprudence. So as I said, I think some guidance would be necessary. But that being said, let's take our break and we'll come back and discuss what the next step should be. Welcome back, and we're here with Vanessa Henri talking about Bill C-27, the new privacy legislation. So we've talked about certain parts of the act. We talked about the new Privacy Act that's replacing other acts, and we've talked about the implementation of a new tribunal, second part of the bundle of acts, and now we're going to talk about the third portion of that bundle, and that's artificial intelligence. And why is that so important? Because Canada's never had any form of legislation that actually tackles this topic. So it's really fun and interesting. And Vanessa, please let us know. What are your thoughts?
Super. Yeah, so you may know Canada has been known to be a country that has developed AI. We have a national strategy on AI, but we didn't have any regulation. We did have something covering privacy, but we didn't have something that was covering specifically artificial intelligence system. What this law does is it tackles the system itself of AI and not necessarily the type of data that's coming in the system. And what it's saying, it is looking at those who are developing it, those who are acquiring it, and those who are offering it to the public. So what is great about this, it means if you acquire your AI from a manufacturer, that manufacturer still has to comply with the law. So you don't only have the little Canadian company that's trying to break the arm of somebody in another country to comply. It is a condition to be in the Canadian market. And what it's telling the companies is that they have to do an assessment to determine if that AI system will be an high impact system. So an high impact system, that will be defined in the regulation. But for those who are in the field now, you can think about artificial intelligence impact assessment. We know it's a thing at the federal level. And what they're looking at here is, of course, right to privacy, but also biases, discrimination. So that's why it's so important that we make the distinction between the de-identified data, the anonymized data, and the personal data, because this legislation is not only about personal data, it's about any data that you're going to put into that system and what does that system do. And what's really interesting there is that it does create exception for anonymized data, and it creates powers for the minister to review this assessment and say, that is a risk. And because it's a risk, here's a series of measures you must have in place in order to deploy your AI into the Canadian public system or into the Canadian market. So it's an entry to market legislation, and that's not something, to my knowledge, that other countries have.
Agreed. I don't think many of them have it. That's why I said this is another part that made it quite unique and definitely a step up from the Digital Charter Implementation Act that obviously died before the federal legislation. So I think there's several good things. This AI, I think, is really good, but I think, as you and I discussed previously, I think it's missing a disclaimer for some of the things that are AI that's forward-facing and user-facing, which is what the public and everyday people see, where if they are going to put an image out there and it looks like it's giving a message or news, then it looks like a real person, there should be a disclaimer that says this is an artificial intelligence. So this way people know and understand. So perhaps it will come, and perhaps we're just tweaking things out.
Correct. And what you're referring to, I think younger people know that as deepfake, right?
Yep.
none of these three acts actually tackle deepfake. They don't say you cannot use de-identified data to create, let's say, engineer something that would be deceiving. So the practice of using data for deceiving purpose is not something that is tackled straightforward in the law. Maybe time will tell if that was a good idea to rely on general principle, but it may have been a lot clearer for a lot of people if there would have been a prohibition from generating deep fake to manipulate people, or generating deep fake without actually revealing that these are not real people. Because nowadays, how do you know that that comment on that restaurant actually comes from a real person or not? And it creates a space where people do not trust the technology. So it might have been a good idea for the government to tackle this forward, to create that trust and make sure that we have an economy that you can have your young people playing it. Yet, I have my kid online, and I want to make sure that he can trust what he's reading, right?
Agreed. Yeah. So honestly, I think you nailed it right on the head. I think it's trust. And at the end of the day, that's where it's great that they have this legislation, but it's missing trust. So thank you, Vanessa. I really appreciate your time. You've been amazing and so insightful.
Thank you so much for having me.
Have a great day. With the advancement of new technologies, one's privacy will be further encroached. Canada was sorely lacking in the protection of its people's privacy rights. If Bill C-27 passes, Canada will move forward with much-needed privacy, cybersecurity, and protective measures. The key takeaway from this legislation is that privacy is important in our society. Stay safe and have a great day.